Please be seated.
The Specialist Chamber of the Constitutional Court of the Kosovo Specialist Chamber, Judge Ann Power Ford presiding, and myself, Riaz Haider, Court Officer, in the matter of Mahir Hassani versus the Specialist Prosecutor's Office, file number KSC CC 201905.
Mirdita, Dobar dan, good afternoon. This pronouncement is a summary of the ruling of the Specialist Chamber of the Constitutional Court, the Chamber, on a referral lodged by Mr. Mahir Hassani, the applicant, with the Chamber on 15 January 2019, the referral, under Article 113, Paragraph 7 of the Constitution of the Republic of Kosovo, the Constitution. The applicant was represented by Dr. Artan Chirkini. Following the Chamber's notification on 13 February 2019 to the Registrar of the date of this pronouncement, the public has been informed in advance of the date and the time thereof. The text of this pronouncement is available on the website in the 3 official languages of the Kosovo Specialist Chambers. In the applicant's referral of 15 January 2019, he complained that an order of the Specialist Prosecutor's Office, the order, directing him as a suspect to provide certain documents and information, violated his right to silence and breached the privilege against self-incrimination under Article 30, Paragraph 6 of the Constitution. He also claimed that the order violated his right to be presumed innocent under Article 31, Paragraph 5 of the Constitution and Article 6, Paragraph 2 of the European Convention on Human Rights and Freedoms, the Convention. The applicant applied pursuant to Rule 21, Paragraphs 1 and 2 of the Rules of Procedure for the Specialist Chamber of the Constitutional Court, the rules, for an interim measure suspending the order, pending a determination by the Chamber of the referral. On 15 January 2019, the President of the Specialist Chambers, pursuant to Article 33, Paragraph 3 of the law, number 05L053, on Specialist Chambers and Specialist Prosecutor's Office, the law, assigned a constitutional panel to rule on the referral. On 18 January 2019, the Chamber allowed the Specialist Prosecutor to file replying submissions in relation to the applicant's request for an interim measure. On 25 January 2019, the Specialist Prosecutor filed those submissions. On 7 February 2019, the Chamber suspended the order insofar as it obliged the applicant to provide the documents, data, notes and information specified therein. The Chamber confirmed that its suspension of the order was without prejudice to its determination of the referral. It also confirmed that it was without prejudice to the applicant's obligation to appear for questioning before the Specialist Prosecutor's Office on 11 February 2019. On 15 February 2019, the Specialist Prosecutor filed a notice of withdrawal and a request for a dismissal of the referral. Having already ruled on the applicant's request for an interim measure, this pronouncement summarises the Chamber's ruling on the substantive aspect of the referral. In so doing, it also sets out the Chamber's response to the Specialist Prosecutor's request for dismissal thereof. The Constitutional Panel, composed of Judge Ann Power Ford presiding and Judge Vidar Stensland and Judge Roland Deckers, reached its findings on the referral following deliberations held both in person and remotely. Factual background. On 20 December 2018, the Specialist Prosecutor's Office served on the applicant 2 documents, namely a summons to appear for questioning on 11 February 2019 and the order to provide certain documents and information to the Specialist Prosecutor's Office on the same day. The order had stated that the applicant was obligated to produce certain documents and information specified therein. The order had also warned that a failure to produce the documents would be considered contempt, as a result of which the Specialist Prosecutor's Office may seek enforcement measures to ensure compliance with the order. The order had further confirmed that there were reasons to believe that the applicant had been involved in the commission of a crime within the jurisdiction of the Kosovo Specialist Chambers. Jurisdiction. In the referral filed under Article 113, paragraph 7 of the Constitution, the applicant complains about the order as issued by the Specialist Prosecutor's Office. The referral thus relates to the Specialist Chambers and Specialist Prosecutor's Office, as required by Article 162, paragraph 3 of the Constitution, and Articles 3, paragraph 1 and 49, paragraph 2 of the law. It follows that the Chamber has jurisdiction to rule on the referral. Findings, preliminary considerations of the law. At the outset, the Chamber recalls its supervisory duty to oversee the work of the Kosovo Specialist Chambers and Specialist Prosecutor's Office insofar as fundamental rights and freedoms guaranteed by the Constitution are concerned. As regards the fundamental rights and freedoms guaranteed by Chapter 2 of the Constitution, Article 22, paragraph 2 thereof, provides for the direct application of the European Convention on Human Rights. Furthermore, pursuant to Article 53, human rights and fundamental freedoms guaranteed by the Constitution are to be interpreted in a manner consistent with the decisions of the European Court of Human Rights. In that light, the Chamber has had particular regard to the case law of the Strasbourg Court in its review of the instant referral. Alleged violations. The applicant's referral concerns the right to silence and the privilege against self-incrimination, as guaranteed under Article 30, paragraph 6 of the Constitution and Article 6, paragraph 1 of the Convention. The referral raises the question of whether those guarantees apply to the investigative stage of criminal proceedings, and particularly to circumstances in which the authorities order a confirmed suspect to provide documents and information during the course of a criminal investigation. The European Court of Human Rights has confirmed that the protections afforded by Article 6, paragraphs 1 and 3 of the Convention apply to a person who is subject to a criminal charge. Article 30 of the Constitution also sets out the minimum rights of a person charged with a criminal offence. The Strasbourg Court takes a substantive rather than a formal approach to the question of when a person can be considered as being subject to a criminal charge. In 2016, in the case of Ibrahim and others versus the United Kingdom, the Grand Chamber endorsed the approach taken earlier in Alexander Saichenko versus Russia, wherein the court had explained that once there is a suspicion of a criminal offence against a person, that person is considered as being subject to a charge for the purposes of Article 6 of the Convention. In that light, the Chamber observes that the order as issued had confirmed that there was a suspicion against the applicant. In view of that confirmation, the Chamber considers that Article 30 of the Constitution and Article 6 of the Convention, more particularly the right to silence and the privilege against self-incrimination, were engaged and were applicable to the applicant's situation. The Chamber recalls that the purpose of the right to silence and the privilege against self-incrimination is to protect an accused person against improper compulsion by the authorities and thereby to avoid a miscarriage of justice. It is the existence of compulsion that raises an issue as to whether the privilege against self-incrimination has been respected. The Chamber is satisfied that under the terms of the order as issued, there existed a clear element of compulsion. It had consisted of a warning that if the applicant had failed to produce the specified documents, such failure would be considered contempt, the threat of legal proceedings being instituted to enforce compliance if the applicant had failed to produce the documents had served to compound the element of compulsion. The Chamber considers it appropriate to recall two relevant strands of the Strasbourg case law on the consequences of such compulsion. The first strand relates to the subsequent use at trial of information obtained under threat. It involves cases such as Saunders versus the United Kingdom, where a suspect provides evidence on foot of a threat of sanctions, and that evidence is subsequently used at his or her trial. In the present case, the applicant submitted that in the event of a trial against him, the documents and data he was ordered to produce under threat of sanction could subsequently harm his defence and give an unfair advantage to the Specialist Prosecutor's Office. The Chamber observes that, unlike the case of Saunders in the United Kingdom, there has been no trial or conviction in the applicant's case. The Chamber cannot speculate whether the applicant would have been put on trial, whether the documents which had been specified in the order would have been used, whether the applicant would have been convicted, and whether the fairness of the trial as a whole, if any, would thereby have been compromised. Had the order not been withdrawn, the Chamber is satisfied that this aspect of the applicant's complaint, namely that compulsion to provide the specified documents would have affected the fairness of a trial, was premature. The second strand of Strasbourg case law relates to sanctions which are imposed upon a suspect for refusing to provide specific information. It arises in cases such as Heaney and McGuinness versus Ireland, where a suspect is requested to provide information under a threat of sanction and subsequently is punished for refusing so to do. The Chamber is satisfied that in such a situation, an issue under Article 6 of the Convention can still arise, even if an individual is not indicted in the underlying proceedings or is acquitted following a trial, if any. In the applicant's submission, the order had constituted an improper compulsion to provide the Specialist Prosecutor's Office with potential evidence, in that it had contained a warning that the applicant's failure to provide the documents would be considered contempt, and a threat that as a result of such failure, enforcement measures could be taken to ensure compliance with the order. In relation to those aspects of the order as issued, the Chamber recalls that in Heaney and McGuinness against Ireland, the Strasbourg Court found a violation of Article 6 of the Convention in circumstances where, during the course of a criminal investigation, the applicants, who were suspects, had been requested under threat of sanction to provide certain information to police officers. The suspects had refused to do so, and the authorities had then prosecuted them for failing to provide the information. In the light of that case law, the impermissible nature of the order which the Specialist Prosecutor's Office had issued was evident to the Chamber. Had the applicant been found in contempt for exercising his constitutional rights, and had enforcement measures been taken against him for so doing, then such a situation could in all likelihood have led to a situation impermissible under Article 30, Paragraph 6 of the Constitution and Article 6, Paragraph 1 of the Convention. In order to preserve the applicant's constitutional rights to silence and to not incriminate himself, the Chamber on 7 February 2019 suspended the order as issued, insofar as it had obliged the applicant to produce the documents and information specified therein. The interim measure ensured that the status quo was maintained pending the determination of the referral. It also ensured that the applicant could not have been found in contempt and that enforcement measures could not have been taken against him should he have chosen to exercise his rights to silence and to not incriminate himself when he appeared for questioning on 11 February 2019. Having examined the applicant's situation, the Chamber is satisfied that as matters stand, there has been no finding of contempt, nor have any enforcement measures been taken against him for failing to produce the documents specified in the order as issued. Had such proceedings been initiated, then an issue could have arisen as regards the right to silence and the privilege against self-incrimination, even if the applicant's status did not change from that of a suspect to that of an accused. Subsequent developments. The Chamber observes that on 15 February 2019, the Specialist Prosecutor filed a notice of withdrawal of the order, the subject matter of the referral, and a request for dismissal of the referral herein. In support of his request, the Specialist Prosecutor submitted that by his withdrawal of the order, the circumstances complained of by the applicant no longer existed. He further submitted that any potential impact of any alleged violation of the applicant's rights had been redressed, firstly by the interim measure ordered by this Chamber, and secondly by the Specialist Prosecutor's withdrawal of the order. In that regard, the Chamber recalls that the European Court of Human Rights has confirmed that a decision or measure favourable to an applicant is not in principle sufficient to deprive him of his or her victim status unless the national authorities have acknowledged, either expressly or in substance, and then afforded redress for the breach of the Convention. However, the Chamber considers that at this early stage of the proceedings, there is no requirement to consider the sufficiency or otherwise of any acknowledgement or redress, particularly in circumstances where the applicant's referral had not been declared admissible prior to the withdrawal of the order. The Chamber considers that in determining whether a case should be dismissed, it may take into account events occurring subject to the lodging of a referral. For the Chamber, the issue of whether the applicant may still claim to be a victim of the alleged violations of his constitutional rights essentially means that the realities of his situation must be taken into account. It also means that developments which have occurred since the filing of the referral must of necessity be considered. In considering all of the circumstances of the applicant's case, the Chamber observes that he had requested this Chamber to declare the order as issued void, or alternatively, quote, to order the Specialist Prosecutor's Office to revoke the said order, end quote. The Chamber is satisfied that by filing the notice of withdrawal, the Specialist Prosecutor has, in fact, and of his own volition, revoked the order. This measure has effectively returned the applicant to the situation he was in prior to the order being made. In these circumstances, the Chamber concludes that there is no longer any objective justification for the applicant to pursue the referral. The Chamber is satisfied that by withdrawing the order, the circumstances objected to by the applicant no longer obtain. It is further satisfied that the effects of any possible violation of the applicant's constitutional rights by virtue of the order as issued have been obviated. It follows that the applicant may no longer claim to be a victim of the alleged violations of his constitutional rights. Conclusions. The Chamber considers that the right to silence and the privilege against self-incrimination under Article 30 of the Constitution and Article 6 of the Convention were engaged in the applicant's situation under the terms of the order as issued. The order was problematic on its face insofar as it had obliged the applicant, a confirmed suspect, to supply the documents and information, and it had warned that contempt would be found and possible enforcement measures taken if the applicant had failed to produce the documents. In accordance with Article 49, paragraphs 1 and 3 of the law, the task of this Chamber is to assess whether the circumstances complained of by the applicant violated his individual rights and freedoms guaranteed by the Constitution. It is not the role of the Chamber to deal with alleged errors made in the course of criminal proceedings, except and only insofar as such errors may involve a violation of the rights and freedoms guaranteed by the Constitution. The complaints in the present case had raised important issues concerning alleged infringements of the applicant's rights under the Constitution by reason of the order as issued. However, having regard to the fact that the applicant's constitutional rights to silence and to not incriminate himself were preserved by the interim measure when he appeared for questioning on 11 February 2019, and in view of the specialist prosecutor's subsequent withdrawal of the order as issued, the Chamber is satisfied that the applicant can no longer claim to be a victim of the violations he had alleged under Article 30, Paragraph 6 of the Constitution and Article 6, Paragraph 1 of the Convention. This finding also applies to the alleged violation of Article 31, Paragraph 5 of the Constitution and Article 6, Paragraph 2 of the Convention, wherein the applicant complained that the order, as issued, had violated the presumption of innocence by having shifted the burden of proof. As the order grounding the applicant's complaints has been withdrawn, the referral must be declared inadmissible pursuant to Rule 14, Paragraph F of the Rules. Pursuant to Rule 21, Paragraph 6 of the Rules, and bearing in mind the specialist prosecutor's withdrawal of the order, the interim measure, ordered on 7 February 2019, expires with immediate effect. This decision on the referral is effective immediately. The decision, having provided this summary of the Chamber's ruling, the operative provisions of its decision are as follows. For these reasons, the Specialist Chamber of the Constitutional Court unanimously declares the referral concerning the order of the Specialist Prosecutor's Office dated 20 December 2018 inadmissible. This concludes the Chamber's pronouncement.
All rise.